Good evening and welcome to another show of Law and Order on another Friday evening. Thank you very much for joining us, and like always we have a specialized lawyer on a specialized area today as well. Mr. Nishan Premithiratne is my guest today. He's been involved in many cases in specializing in commercial litigation, commercial arbitration as well, and he has also been involved in working with the World Bank doing an index on contracts, commercial enforcement of commercial contracts in Sri Lanka, and Nishan had been working under several senior lawyers in Sri Lanka. His practice sails from company law to commercial law to a wide range. Nishan, I'm not going to give you a full CV, but welcome to the show.
Thank you very much.
How are you doing today?
Not too bad, not too bad.
Good. Now, you mainly practice in the field of corporate law and commercial law, like I was just briefing in my introduction. What are the changes? Now, we all know it's about 10 years now, the Companies Act, which came onto board in 2007, Act number 7. What are the changes that are important for the public to know that were brought about by this Companies Act?
Okay. Before the Act of 2007, there was a Companies Act of 1982. Yeah. The 2007 Act, at its outset, seeks to have a single shareholder company. Yeah. So, in the previous Act, we were not able to have a single shareholder company, but the new Act has provided for single shareholder company. So, with one shareholder, the company can be commenced. Then thereafter, you get also the taking out of the object clauses of the Companies Act. So, if a company has in its objects a certain business which the company is to be engaged in, and if the company is acting against that objects, that is called the doctrine of ultra vires. So the doctrine of ultra vires has been taken out. So a company need not strictly adhere to the nature of the business which it initially thought of commencing and continuing. Then thereafter, we also see in the new Companies Act a separate chapter for directors' duties. So a director of a company is part of the management of the company. So the company has to be controlled. So you get the shareholders who are the owners of the company, and you get the directors who do the controlling or the managing of the day-to-day affairs of the company. So the directors are also given certain duties and obligations, and in respect of imputing their expertise in managing the company. So a separate chapter has been brought in to the Companies Act from sections 188 to about section 215 in respect of directors' duties. So in addition, the new Companies Act has also provided for a specialized court to hear disputes in respect of company matters. So that is the court which has been established in terms of Article 154P of this Constitution that came pursuant to the 13th Amendment, and we call it the Commercial High Court. So this Commercial High Court right now is situated in the Western Province and situated in Colombo, which has been given the exclusive jurisdiction to hear and determine disputes which arise out of this Companies Act have to be heard by this exclusive court which is vested with the powers. So thereafter in the Companies Act you also find chapters in respect of winding up of a company. So winding up of a company is basically killing the company, or the company coming to its end. So you get a chapter in respect of winding up, in respect of amalgamations, mergers. So it's quite a comprehensive piece of legislature comprising of more than 529 sections.
Right. You said single shareholder, which also means single director can be.
Yes.
Single shareholder, single director can be the same person.
Correct.
This is a bit of a confusion certain people do have.
Yes.
Do I need two directors still and single shareholder?
Yes.
Of course, if you get proper advice, it won't come through.
Yes.
Now, in a company, in certain countries, you can choose any name and make a company name.
Yes.
But we have certain restrictions. Are the restrictions still there, or can I, for example, take any name and form a company in Sri Lanka?
Your decision on selecting your name would be subject to a search, an initial search which you would have to carry out at the Registrar of Companies. Right. So the Registrar of Companies is situated in Colombo 10. You merely have to go there with your name and you can do a company search.
Yeah.
So your name also is subject to certain preclusions. You cannot use, for example, the name of Sri Lanka in your company name without special approval from the registrar.
Right.
Your name cannot be misleading in respect of a name which is already in existence. So basically in a recent case which we decided in the commercial court was where two companies which were using the name very similar to each other, and one was challenging the registrar's decision to permit this second company from carrying or being permitted to have a similar name. So misleading names are not permitted, and there are certain words such as Sri Lanka, such as Parliament, etc., which cannot be used unless special permission have been obtained from the registrar.
Okay, I can understand trying to rob a company's name, which, for example, which you have registered. I'm trying to get it.
Yes.
That's reasonable. But why restrictions on names like Sri Lanka? Well, if you look at the countries like the United States, you have a company called American Airlines, which is not a US government thing. It's a private company.
Yes.
So there are no restrictions in those countries.
Yes.
You can even use the word president.
Yes.
I don't want to mention a particular company which has the word president and whatever.
Yes.
So why do you think, what is the thinking behind putting these restrictions?
When a company is incorporated and say it carries the name Sri Lankan Tea Private Limited.
Example.
Yes.
Yeah.
So then the third party or any party who is to deal with the company would get the intimation that this is the company which is set up and associated and affiliated with the state of Sri Lanka.
Right.
So that should not be the, because
that is our thinking.
Yes, it might be the wrong representation created. Actually, there might not be any state interest in that company, but the company might create that interest or intimate that to the public with a name of that nature.
Now, in a company, what is the general setup? How are the directors and the shareholders? We all know directors have fiduciary duties and all that, but how are they kept in check?
Now, as in our country, we've got this thing called the Constitution.
Yeah.
So the Constitution governs the judiciary, governs the legislature, and governs the executive. So it's like a tripartite agreement. Likewise, the company, any company for that matter, whether it is a private limited company or a public quoted company, has a thing called the Articles of Association. So the Articles of Association binds the company, the shareholders, and the directors of the company. So if the directors are acting in violation of the articles, the shareholders can take action. So this is the initial document which binds all three of these parties. Furthermore, the Companies Act has also provided for shareholder rights. Now in section 49 of the Companies Act, you get the rights of the shareholders.
Right.
So in terms of section 204, it is provided that the appointments to the board of the company is subject to ordinary resolution. So what is an ordinary resolution? An ordinary resolution is a resolution voted for by 50% of shareholders attending a shareholder meeting. So ultimately, it is the shareholders who can decide whom to put onto the board, whom to take out from the board. And also, so say you are a minority shareholder, you only have about 2% in a big company. So what do you do? Now say the articles are in a manner which has to recognize certain rights of yours. And then the company, the board has decided to act in violation. So what do? You have remedies in the Companies Act. You have actions of oppression. You have an action for mismanagement under sections 224 and 225 of the Companies Act. Then you can get restraining orders on the directors if the directors are going to violate the articles. So although you might have only a minute share, you might have only 0.1% of a public quoted company, you can still bring in activate provisions from the Companies Act to hold the directors in check.
Right. Now, we have a thing called object clause in the articles.
Yes.
What is the use of this object clause? And once we put an object clause, can we divert wholly out of it and do something else? For example, example, I'll create a company with object clause for construction. Can I dump the construction area and do television broadcasting on that? Is that possible?
Yes, it is possible. Now, one should appreciate the purpose of an object clause. Now, the purpose of the object clause is to ensure that the shareholders and the directors have all agreed that this is what our company is going to be doing. Now, under the previous law, if the company entered into a contract with a third party in respect of a certain arrangement, say, as you said, a construction company, it entered into a contract with a third party to provide security.
Yes.
Right? So then thereafter, in terms of the old law, the company could have come back and said, hold on, we have acted in ultra vires of our object clauses, and hence you cannot enforce the contract against our company. Right. Now that was a dangerous precedence which would have been created, and that was created those days. But fortunately, that has been taken out. So even if the company acts against and beyond its object clauses, a third party need not worry. Third party can enforce that contract against the company.
Right. Then we have this difference of companies and public companies, the quoted companies, or the private companies. Now, what is the difference of this is my one question. The second question is the Companies Act, which came Act number 7 of 2007. Does it apply to both companies, or is there a different set of or additional set of rules applying for the public companies?
That's a good question, Chanakya. Now, one should appreciate that everything is a company, whether it is public or whether it is private. So the basic principles of the company law, or the four corners of the company law governing all companies, will apply to a public company and also to a private company. Now, say you are a shareholder of a public quoted company, and say the public quoted company is going to act in contravention or in violation of the Companies Act. So in such an instance, in that public quoted company, a shareholder will have a remedy in terms of the Companies Act to go to the Commercial High Court and sue the board and take control of the company.
Right.
Thereafter, then you ask me the second aspect of this question as to whether there is what is the difference between a public quoted company and a private quoted company. So you say, for example, yourself and myself, we form a company. I issue one share to you and one share to me. So we two are the only people who are the shareholders. Now, that is a private company because the public don't have the ability to buy into our company unless you and I decide.
Yes.
But however, in a public quoted company, you see the Colombo Stock Exchange. Yes. You see that certain parts of the equity or shares are listed in the Colombo Stock Exchange, giving the ability to the public to buy shares or buy into corporates, conglomerates, buy into shares and take part of the equity of those companies. So the question is, yes, there is separate regulations in addition to the Companies Act. In addition to the Companies Act, which govern or which control public quoted companies. And the main regulator is the Securities and Exchange Commission, which regulates the public quoted companies. So there is an act, and there is also the Takeovers and Mergers Code, which govern these companies in respect of the dealings and the transactions in respect of those boards. So in addition to the Companies Act, you get the corporate codes of governance, where those are voluntary codes which embark a certain corporate responsibility on the directors of such company to abide by these regulations and guidelines as stipulated in the SEC regulations, specifically applicable, only applicable to listed companies.
We have lots to go through, but we may have